I'm having some challenges with my video, but we will get started very shortly. All right. My computer is completely not working today, so I am appearing from my iPad. Is everyone able to hear me?
Yes, Judge.
All right.
Yes,
All right.
Your Honor.
Good afternoon. Thank you. This is the state expedited accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today. Those who receive a signature or a signature bond will be reset for the notice. Those who receive a surety or cash bond will be reset to the state all-purpose calendar on September the 15th. All right, who do we have first?
Good afternoon, Judge. This is position 5, Ms. Mansour.
All right, good afternoon. Your case number is 22 CR 005913G. I'm Judge Melanie Williams. Do you understand those rights as I just read them to you?
Yes, ma'am.
All right. In this case, you're charged with 1 count of criminal attempt to commit a misdemeanor and 1 count of injuring or tearing down a mailbox with the offense date of August the 31st.
Your Honor,
Yes.
I apologize. I do not mean to interrupt. There are actually 3 co-defendants on that case. This is position 3, position 5, and position 8. So this is actually a 3 co-defendant case, literally all the same facts.
Great. If we could do those 3 together at the jail, that would be
correct, Your Honor.
ideal. All right. All right. And Ms. Falk, are these your cases?
Yes, Your Honor. I'm handling all the cases today.
All right. All right. Okay, go ahead, Ms. Falk. We're ready. Oh, actually, may I have the history, please?
Yes, Judge. Are we starting with position 5?
We'll start with position 5.
She has 2 cycles, both out of Arkansas, with the last being from 2020 for forgery in the 1st degree. There's no disposition listed. And then a 2019 FTA and nothing
All right.
further.
Thank you. The other defendants don't have to stand, but I would just like to go to those cases next. All right, Ms. Falk.
Yes, Your Honor. As for all 3 defendants, and I'll address them one at a time as they come up, but as for all 3, this incident happened on September 1st, 2022 at 121 Woodway Park Drive in Atlanta, Georgia. The defendants were observed trying to break into a mailbox using a screwdriver and a crowbar. The screwdriver was actually wedged into the mailbox, which was damaged. The defendants do not live in the area and do not receive mail at that mailbox. They initially stated that a package had been delivered to that location by accident and they were trying to retrieve it, but there is no proof that the package actually belonged to them, or this was, and regardless, this is not the appropriate way to retrieve a package that was delivered to a wrong address. Multiple screwdrivers and crowbars were also found in their possession. There's currently a bond of a $500 surety bond for each of these defendants. For Mansour, which is position 5, we are asking that $500 surety bond remain. That's $250 for each charge. The reason why is because Mansour, this defendant, is quite frankly a flight risk. Between the FTA in 2019 and the forgery in 2020 out of Arkansas, we have concerns that the defendant is both a flight risk because they failed to appear in court in Arkansas once before in the last 3 years, and also because we are not showing, based on the fact that the most recent case was 2020 in Arkansas, that this person does not have significant ties to the community. That is all.
Thank you, Ms. Falk. Who represents this defendant?
I do, Your Honor.
All right, and your recommendation.
Good afternoon, Judge.
Good afternoon. I know it's strange to see me. If I move, I disappear. So hopefully we'll get through this. Your recommendation, Ms. McLeod?
A signature bond, Your Honor. My client is 23 years old. She is a sole caretaker for her 5-year-old son. She denies that she had any kind of criminal intent. And she tells me that, in fact, she expected a package and the package for some reason was sent to an incorrect address and she was just trying to retrieve her package. She is presumed innocent, Your Honor. She does not have any she doesn't have any convictions based on what I thought I heard pre-trial say, and she does have a 5-year-old son. My understanding is that this mailbox was not at an occupied building at all. So she says it was just that it was misdirected, a package she was expecting.
All right, thank you, Ms. McLeod. The $500 surety bond will remain as set for this defendant. All right, best of luck to you, ma'am. Can we go to position either one of the co-defendants? It doesn't matter, I'll let the jail decide.
Your Honor, and the state is asking for, my apologies, for a stay away from that location and no alcohol, drugs, or weapons.
All right, I will do
The
this.
stay away is, we do not object to the stay away.
All right, those special conditions will apply. To stay away from the incident location and no alcohol, drugs, or weapons as the condition of the surety, and she will be reset to that SAP date as previously explained.
Judge, I'm sorry, what's your breakdown?
It's
$250 each
yeah,
charge,
is requesting $250 per count.
$250 per charge as set.
Thank you.
I didn't change the bond. All right, who's next?
Position 3, clink scale.
Okay, Ms. Cleanscale, your case is 22 CR 005912G, in which you're charged with tearing down a mailbox and criminal attempt to commit a misdemeanor. Do you understand your rights?
Yes, ma'am.
All right, the history, please.
Does not have a criminal history. She's recommended with a parental cosigner. She's 17.
All right.
We are showing that this is the first arrest for Ms. Clinkscale. The facts remain the same, and the state is asking for and the bond is currently set at 500 surety. We're asking for a $2,000 signature bond, 1,000 per count through pretrial. No alcohol, drugs, or weapons. Stay away from 121 Woodway Park in Atlanta, Georgia.
Thank you. Who represents this defendant?
Good afternoon, Your Honor, Wanda Gant.
Good afternoon, Ms. Gant. I'm assuming you don't object to the signature bond.
No objections, Your Honor, and I did speak out with her mother, Ms. Dominique Thompson. She is willing to co-sign. However, she has an Arizona driver's license and she does not have a utility bill.
I'll waive the utility bill. At this time, defendant's going to receive a $2,000 signature bond through pretrial. She's to stay away from that incident location, and she's to have no alcohol, drugs, or weapons. I'm going to waive the utility bill requirement.
Thank you.
Is there anything further? I'm sorry.
Would you like for me to email that?
Yes, if you please email it to me as a PDF. I'm having computer issues and I cannot open any Word documents for some strange reason. So, and I can only open what I can open on an iPad.
Gotcha.
All right.
Okay.
Thank you so much. All right. Best of luck to you, Ms. Clinkscale. Let's go to position 8. I believe the other co-defendant, Mr. Walker. Mr. Walker, your case is 22 CR 005914G, in which you are also charged with attempting to tear down a mailbox and criminal attempt to commit a misdemeanor. Do you understand your rights today?
Yes, ma'am.
All right, the history, please, Ms. Roberts.
I have to go grab this one from my coworker. She asked for felony court. So give me one.
Okay, this let's see if Ms. Falk. Ms. Falk, do you have that history?
I do indeed. The defendant has one conviction for theft by shoplifting in 2017, a felony firearm arrest from Florida in 2022, a felony drug arrest from 2021 that is still open, in FTA from 2021, and his history dates back to 2015. Let's see, there are.
I think I've got the flavor, Ms. Falk, your recommendation.
State's recommendation on this one, Your Honor, is a $1,000 surety bond, 500 per count, no alcohol, drugs, and weapons, and stay away from the location. Obviously, his situation is different than his co-defendants based on the previous conviction as well as his history out of Florida, which both makes him a flight risk and a risk of reoffense. Nothing further.
Thank you, Ms. Falk. Who represents Mr. Walker?
It's me, Your Honor.
All right, Ms. McLeod, you represent him as well. Okay, I was making sure that even though you represent one co-defendant, there's no conflict in you representing the other.
That was my understanding, Your Honor. The public defender is
All right, for the time being, we'll go with it, Ms. McLeod. All right, I'm inclined to take the state's recommendation here, but of course, I'll hear your argument.
Yes, Your Honor, he is a resident of Georgia and has been a resident of Georgia. He was born in Georgia. That's what he tells me. He is not working right now, Your Honor, because he just received his CDL license and he's looking for a job as a CDL driver. He said he was just with some friends and he was just helping them to retrieve a package which had been missent. The facts have been stated already, and he just happened to be there.
All
And,
right.
you know, that's his position on this, Your Honor.
All right, defendant's gonna receive a $750 surety bond, $250 for the criminal attempt and $500 for the mailbox. He must stay away from the incident location and have no alcohol, drugs, or weapons as a condition of that surety bond. Is there anything further from the state of defense?
No, Your Honor.
All right,
No, Your Honor.
best of luck to you, Mr. Walker. Who
The
do we have?
state-
I'm
the
sorry.
state does- Right, the state does have one request. Can we address Mr. Ramirez's case? It's a breakout and I would like to release our victim advocate.
All right, now let's hope I can do a breakout on this. I've never actually held this on an iPad. Let's hope I can do it. All right, if we could do Mr. Ramirez, the breakout case, and I be placed in the breakout,
Let me find out.
hopefully it'll just happen automatically.
Are you talking about you want to do that now, right now?
Yes, please. Apparently they want to release the advocate. Can we do 7 Ramirez? Mr. Ramirez, your case is 22 CR 005915C, in which you're charged with 1 count of battery family violence with the offense date of September 1st. Do you understand your rights?
Yes, Your Honor.
All right, thank you. Can I have the history before we go into the breakout?
Yes, 1 second. He has no prior criminal history. First arrest.
Thank you so much. All right, if I could be placed in that breakout, please.
Ms. Gank, check the chat, please.
I believe Ms. Kim and myself will also need to go to the breakout. Thank you.
Gant,
All right, I am sounding now for Ms. Catherine Bear. Ms. Bear, if you are on the Zoom conference and wish to make a statement, this is your opportunity to do so. You are not required to make that statement. If you do, I would just need you to turn on your camera and unmute yourself.
Hi, Judge. I guess I would
Bef-
just like.
Before
I'm
you
sorry.
talk, please raise your right hand. Do
Okay.
you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
Okay, before you start speaking, I don't want you to say anything sensitive. You can put your hand down. What I'm most concerned with is whether you'd like to have contact with the defendant at this time.
I feel very safe with him. I'm not concerned about any kind of harm.
All right, thank you. And I did hear through the state, so I'm aware of the situation. All right.
Okay, thank you.
At this time, the defendant's going to receive a $4,000 signature bond through pretrial services. He is to have no further violent contact with Ms. Bear, and he is to have no alcohol, drugs, or weapons as a condition of that signature bond. His case will be reset further notice. Is there anything further from the state of defense?
Nothing further, Your Honor.
No, Your Honor.
All right. Good luck to you, sir. We can move to the next position.
Judge, are we
Nine,
doing
Westfield.
BHET?
I'm sorry, there was a question?
Yes, this is Melissa, Judge. Are we doing the BHET?
Oh, yes, I'm sorry. And evaluation doesn't schedule breakout. Thank you, Ms. Gray. All right. I'm sorry, what position is this?
Position 9, Westfield.
Right. Good afternoon, Mr. Westfield. Your case is 22 CR 005916. In which you're charged with 1 count of simple battery and 1 count of obstruction with the offense date of August the 31st. Do you understand your rights?
I stand over.
I'm sorry?
I stand over it.
You stand over it?
Say
Yes.
yes.
Yes,
So does that mean you understand?
I hear you and I hear you. Yes, I understand.
You. It's been a confusing enough day. Let's use regular language, please. All right, Miss Roberts, can I have the history, please?
he has 8 cycles. Last arrest was March of 2019 for willful obstruction of a law enforcement officer and disorderly conduct out of DeKalb County. Those cases were dismissed. He does have a 2014 conviction for disorderly conduct and willful obstruction of a law enforcement officer, a 2013 conviction for willful obstruction of a law enforcement officer, criminal trespass, and disorderly conduct, and then a 2013 conviction for possession of marijuana less than an ounce. And nothing further to add.
Okay, thank you. All right, Ms. Falk, I believe this is your case.
Yes, Your Honor. Ms. Roberts, I'm also showing a history out of Florida. Are you seeing that as well?
Let me check.
We'll defer to the state.
Right. And while Ms. Roberts is checking, I can go over the facts. This happened at 2641 Main Street. The defendant slapped his mother, Miss Geraldine Hill, and that's JeaRolyn, in the face. When the officers arrived and attempted to place the defendant under arrest, the defendant essentially prevented the officers from detaining him by not complying to the lawful commands. He stiffened his body. And when they tried to put him on the ground, he kept trying to lift himself off the ground while they were giving him lawful commands to remain there, and essentially just obstructed the officers from being able to effectuate the arrest properly. This happened yesterday at 8:04 p.m. So my apologies. August 31st at 8:04 p.m. We are asking for a $3,000 surety bond. That's going to be $2,000 on the simple battery, $1,000 on the willful obstruction of law enforcement. We're asking for 1 day anger awareness, stay away from the residence located at 2641 Main Street, no further contact with Miss Geraldine Hill, and 1 day anger awareness, and no alcohol, drugs, or weapons. We will cite to the defendant's history out of both Florida. We have two 2018 cases. That one was dropped and one was an open arrest. Resisting officers is the open arrest. Tampering with physical evidence was the arrest that was later dropped, as well as a null prost battery, and the convictions for willful obstruction and disorderly conduct out of Georgia, which give us both concerns for escalation as well as general concerns for risk of reoffense. That is all from the state.
All right, thank you. I'm going to sound for Ms. Hill. If Ms. Hill is on the Zoom conference, this is your opportunity to speak. All right, hearing none. We'll go. Who represents this
May I
defendant?
speak?
I do, Your Honor.
All right.
Mr. Christopher Westfield, please remain silent.
I wish to
Every
speak.
right to remain
I
silent.
wish to speak.
Please don't speak. The best
I
thing
wish
you
to speak.
Okay, let your attorney do her presentation. At the end, if there are remaining questions, I may hear limited things.
No,
Right.
Ms. Kelly made a mistake.
Please, Mr.
Please.
Christopher Westfield, you have every right to remain silent, and anything you say will be used against you. I strongly recommend you to stay silent, and I'll call you if you have any further question. Let me represent you first. Your Honor, Mr. Christopher Westfield is 36 years old, Your Honor, and he has been here in Georgia almost 34 years, except a few times he was out of town to Florida, I guess. He has 4 children, and they're all minors, 9 years old, 4 years old, 5 years old, and he's divorced. Your Honor, he works at eBay, and also he works for his mom, who is a real estate broker. He fixes houses and he gets paid for his service to his mother. This incident happened, and my client denies any kind of violence whatsoever. It was mother-son kind of like interaction, friendly touchiness, but he's very big. He's 6'4", so just being standing, he comes across kind of intimidating. And even though he does not mean to, he may be misunderstood because of his height and size. And police indeed slammed his head to the concrete so much that his head was hurting. That's why he tried to get up, because he wanted to protect his head. And I don't think that there was actual willful obstruction, Your Honor. We would like to request for signature on bond for this. And because it was not an altercation situation. He was trying to help his mother, who had a flat tire at the time. And he has a lot of family members here, aunts, uncle, and his mother, of course. And he graduated from, he didn't graduate yet. However, he did 4 years of college at Albany State University studying accounting, but he had to have a medical leave. And he also applied for Peace Corps, but he's in active duty. Since he's a vegan, he's not able to eat anything at the jail right now. So he's been very hungry. We would like to request for signature on bond. And if Your Honor is not inclined to give him a signature on bond, the maximum we would like to request for $1,000 good bond. Thank you, Your Honor.
All right, at this time, defendant's going to receive a $2,500 bond, surety bond on count 1, and a $500 signature bond through the jail for count 2, for a total of a $3,000 split bond. He is to stay away from 2641 Main Street, and he is to have no further contact with the alleged victim, last name Hill. He can return one time with a member of law enforcement if he needs to get anything from that location on Main Street, and he is to have no alcohol, drugs, or weapons as a condition. Is there any further from the state of defense?
Yes, Your Honor. Geraldine Hill's first name is JeaRolyn.
All right,
May I
thank you.
speak?
Ms.
No,
West,
no, please.
I
Call
want
me.
to speak. I want to speak.
I'll call you and then I'll come
Call
to
I
you.
Ms.
want to talk. I want to talk to the judge, and because she made a mistake.
Oh,
And you
I
made a
will,
Everybody made a mistake. I would like to speak. I have
Okay.
freedom of speech.
I wouldn't have a record, for the record, that I advise my client not to speak.
Thank
I'll
you.
allow him to talk.
And you're, thank you. I would like to speak.
very quick, Mr. Westfield.
Okay.
Please talk about the case. Do not
I-
tell me. Go ahead.
I did not try to get up or move at all. I remained completely still. The officer slammed my head on the ground and picked my head up and slammed it down. I did not move at all. I stayed completely still. I did not do any movement.
Talk about the facts of the case, but I want you to remind you, I gave you a signature bond as to that particular charge, okay? So you received a surety bond and
I don't have any funds. If I could please receive a signature bond for the other charge, because I did not injure my mother.
stand. All right, thank you. Please call Ms. Kim with any questions. Thank you. We can move to the next. Who do we have next?
Position 2, Calvin.
Trying to save my mama from driving with a flat tire, man.
All right, Mr. Calvin, your case is 22 CR 005911B, in which you're charged with theft by taking with the offense date of September 1st. Do you understand your rights?
Yes, ma'am.
All right. Can I have his history?
I'm showing he does not have a criminal history. He's recommended with the co-signer. He's 17.
All right, thank you. Ms. Falk?
Yes, Your Honor. On September 1st, the defendant stole 5 pairs of shoes from his employer at Rack Room Shoes at 1801 Howell Mill Road, Northwest in Atlanta, Georgia. The 5 pairs of shoes were valued at $538.95. The defendant had the items scanned by another employee for the actual dollar value and then voided out the transaction to 0, which is how he was able to take possession of the goods. There is currently a bond of a $1,000 surety bond based on the fact that this is the defendant's first arrest. We would be asking for a $2,000 signature bond through pretrial with the co-signer given his age. Also a stay away from Rack Room Shoes, no alcohol, drugs, and weapons. Thank you.
All right, thank you. Is this Ms. Kim's case or Ms. Gant?
Ms. Gant, Your Honor.
Gant, do you object to signature bond?
No, Your Honor, and with regard to a co-signer, I've been in touch with, well, my colleague has been in touch with his mother, Vanity Jones. She is willing to co-sign, but we are asking to waive the utility bill.
All right, I'll waive utility in light of his age and the information before me. He's going to receive a $2,000 signature bond through pretrial services. Anything for the defense? And he must stay away from that Rack Room Shoes.
Nothing from the defense. Thank you, Your Honor.
Mr. Calvin, don't do that anymore. All right, who do we have
Ms.
next?
Gant.
Position 10, Wimby.
Ms. Gant.
Yes, I am responding to you pre-trial. Thank you so much.
I need the name for the previous one too, please.
Yes, I will. Thank you.
Thank
Ms.
you.
Wimby, your case is 22 CR 005918, in which you're charged with failure to maintain a lane with the offense date of September 1st. Do you understand your rights?
No.
All right, the history, if you have the driving history, Ms. Roberts, that would be helpful.
I didn't hear the position number.
10. Mr. Wimby.
Wimby. I'm showing 8 cycles, last arrest 2015 for a probation violation. 1 conviction for criminal trespass from 2011. He had a 2013 knowingly driving motor vehicle on suspended, cancel, or revoked registration. There's no disposition listed. And I don't have his full driving history, but I could run it if Ms.
I
Falk
have his
doesn't have it.
full driver's history, Ms. Roberts. I can address that if you like.
Thank you.
We'll defer to Ms. Falk. Ms. Falk, your presentation, please.
Yes, Your Honor. So just as far as the driving history is concerned, we're showing a June 2017 failure to obey stop sign, which he pled nolo. A August 2017 following too closely, which I don't have a disposition on. A July 2017 improper erratic lane change where he pled nolo. And August 2017, basically what looks like a suspended license. A 2017, March of 2017 speeding, 52 and a 35, a failure to maintain insurance in 2016, January of 2016, along with an improper U-turn where he pled guilty. And after that, it goes to 2015. I just wanted to cover the last 5 years of history. But he does have other offenses stretching back to 2015 and 2014, as well as 2013. So the state's case in this situation is apparently officers observed this defendant on September 1st approaching Metropolitan Avenue traveling on University Avenue. He was driving at a high rate of speed and changing lanes without signaling. At that point, the officer initiated a traffic stop. He observed the defendant would not roll down his window and proceeded to place an item in the glove box. Upon knocking on the driver's window door, the defendant continued to move about in the cabin of the vehicle. He then rolled his window down and claimed he didn't see the officer or hear him. At that point, the defendant was removed and detained, obviously for officer's safety. Upon detaining the driver, they were able to obtain his driver's license and confirm he was wanted on outstanding warrants. While they were detaining him, they smelled the distinct odor of marijuana. They did a impound of the vehicle as well as an inventory, found a forged $50 bill in the center console, 1 gram of marijuana in the front cup holder, and a clear plastic bag and an open can of Red Bull mixed with what appeared to be alcoholic beverage in the cup holder. They also found a Smith & Wesson loaded handgun in the glove box with a full
I don't ask Ms. Gant twice.
Okay.
I'm sorry.
With a full magazine and 1 round in the chamber. We do obviously have some concerns here. I'm not sure why this is the only warrant that was taken out. My understanding was that citations were also forthcoming based on the police report, although I could not locate any other citations. The defendant currently is on a $265 surety bond on this case. We asked that the bond remain the same given his driving history. He also has what looks like a surety bond on a different case that looks to be a rearrest, which also does give us some concerns regarding the defendant's possible failure to appear. But that was a 2019 case. So we are asking the bond remain the same at $265 and the defendant have no alcohol, drugs, or weapons. That is all.
Thank you. Is this
Yes.
Ms. Gant's case?
Yes, Your Honor. We would like to request for signature on bond for this. He is recommended. He is Mr. Welfare Wimby is 35 years old, and he has been here in Georgia all his life. He has 2 children who are minor, and he has his family. And also he is gainfully employed at Instacart for the last 2 years. So I don't think he is a flight risk, Your Honor. He did not receive the notice of hearing properly. That's why he has a bench warrant out there for the pending. However, we have a concrete address now that he can receive the mails that he's going to be able to come to the courts for this. And he has a 1 year of college education. He does not have any physical disability or mental health issues, and he's not addicted to any kind of drugs or alcohol. We would like to request for a signature on bond. And I do understand there are histories, but they are from 2015 and also driving histories. Please consider signature on bond for traffic tickets, Your Honor. Thank you.
All right, at this time, the defendant will receive $1,000 signature bond. He is to have no alcohol, drugs, or weapons. That's a condition of that signature bond. Is there anything further from the state of defense?
No, Your Honor.
I'm
Nothing
sorry,
further, Your
Joe,
Honor.
you sound
Thank you.
broken up. What's the bond again?
$1,000 signature. I apologize. It might be my iPad. Are you able to hear me now?
Said 1,000 SOB through the jail?
Yes.
Okay, thank you. Next position is 6, McNair.
Thank you.
All right. Good afternoon, Mr. McNair. Your case is 22 CR 005917A, in which you're charged with theft by taking. Do you understand your rights? Ms. Roberts, can I have the history, please?
Yes, he has 55 cycles. Last arrest was April 22nd of this year for criminal trespass, dissemination of information relating to terroristic acts via computer, and simple assault with MARTA. He has a total of 6 theft by shoplifting convictions, 3 criminal trespass convictions, with the most recent being this year. 2014 disorderly conduct conviction, a driving while license suspended or revoked conviction, 2019.
That's sufficient, Ms. Roberts. Thank you. I think I appreciate that. Ms. Falk?
Yes, Your Honor. This incident happened September 1st on 2022 on Marietta Street. The defendant took a tan purse valued at $20 and containing United States currency, a Georgia ID card, as well as a Social Security card, and a glass pipe belonging to Tiffany Agnew. That is Tiffany, Agnew, Agnew. My understanding is the defendant is residentially challenged. The state's recommendation, again, as pretrial has stated, this defendant has 55 cycles, stretching pretty far back and going all the way up until 3 criminal trespasses in 2022, a disorderly conduct in 2020, a disorderly conduct criminal trespass, possession and use of drug-related objects in 2020, theft by shoplifting in 2019 that was transferred to the DA's office, so on and so forth. So the state is recommending a $2,000 surety bond, no further contact with Ms. Tiffany Agnew. We are not asking for a stay away since this appeared to happen on the street and not at a residence. And that is all for the state. Oh, and now no alcohol, drugs, and weapons. Thank you.
Thank you, Ms. Falk. Ms. Kim?
It's me, Your Honor.
Oh, I'm sorry.
Your Honor, my client is 60 years old, and despite his somewhat extensive history, he is presumed innocent in this case. He tells me that he actually was the victim. He is disabled, but he does try to sell little nicks and knacks for a living, and he has a bag in which he carries around the things that he sells. He said that the alleged victim and one of her acquaintances tried to snatch the bag which contained the goods that he was selling. And the gentleman who was with the complaining witness actually attacked him, and he had to defend himself from them. He was, trying to pull his stuff back that belonged to him. He absolutely denies that he stole anything, Your Honor. He says that it's absolutely not true. And my understanding is that the complaining witness was herself arrested. At least that's what my client tells me.
Right.
My client is, as the prosecutor noted, he is residentially challenged. He does not have any money. He gets disability, but it's really insufficient for him to live on. That's why he has to, kind of rely on the generosity of people, of his acquaintance, because he cannot maintain a household on his own. I would ask the court to take that into consideration in setting a bond for him, despite his history. Thank you, Your Honor.
At this time, defendant's going to receive $1,000 bond. He have no that and is
talking. I can't speak out while she's talking. Man, I didn't do anything to that girl. Them girl ran me down on the street on the sidewalk and stabbed me up with a knife. The ambulance and everything with that. I hadn't did it. Now you see my hand? You see how the girl stabbed me up? She stabbed me in my heel and stabbed me in my back. The same one. I ain't did that. I don't even know these women.
Okay.
They attacked me to take my bag. I mean, I got cuts all over. You see my hand? I got cuts all over me from this girl stabbing me, and I'm walking through. I go downtown and sell product every day. I don't even know that girl. I ain't talking no pocketbook. I ain't talking nothing. I don't even know them people. I'm just selling products. I do that. And besides, I got my check the same day. I get a disability check every day, every month. I had $800 and something on me. Plus, I got $1,000 worth of stuff like that. Why would I take up her? She ain't got nothing. She's stuck in dick.
Right.
Mr. McNair,
please speak about regarding.
Ain't did nothing on phone. That lady stabbed me in the middle.
Please stop talking to
Mr. McNair.
And no alcohol, drugs, or weapons. All right, we can move to the next position.
Judge Williams, actually, I was going to tell you, you were breaking up when you were making the announcement, so you may need to make it again for the court, for the courtroom.
I'm really having some challenges with my technology today. It's $1,000 surety bond. He is to have no alcohol, drugs, or weapons, and no Miss Agnew.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Best of luck to you, sir. Who do we have next? Hello, am I frozen? Please say I'm not frozen. All right, who do we have next at the jail?
You are not, Judge Williams. It appears they're addressing the last defendant and just getting him moved out before they move the next person in.
Okay, thank you, Ms. Falk, for that. I'm unable to see all of the screens. All right, who do we have at courtroom 2?
It looks like she's still putting the other defendant in, right, Judge?
Did I see?
Yes, it looks like they're still working on it.
Yes, this is gonna be position 11, Mr. Wyatt.
All right, Mr. Wyatt, your case is 22 CR 005919A, in which you're charged with obstruction and possession of marijuana and pedestrian darting in and out of traffic. Do you understand your rights?
Yes, ma'am.
All right, can I have the history, Ms. Roberts?
I'm showing 12 cycles. Last arrest December 2021 for driving while license suspended in Noonan, Georgia. That case, there's no disposition listed. He has a 1997 conviction for cruelty in the first and aggravated battery, a 2012 conviction for driving while license suspended, and a 2017 public indecency conviction. And nothing further to add. He has a total of 4 probation violations in his history.
All right, thank you. Ms. Falk?
Yes, Your Honor. This happened on September 1st, 2022 at 205 12th Street Northeast in Atlanta. Officers were actually dispatched to 1080 Peachtree Street regarding an alarm call. Upon his arrival, he observed the defendant walking on the sidewalk outside the location. After clearing the alarm call, he saw the defendant still on the sidewalk. The defendant fit a person of interest who had been involved in multiple incidents within that area. The officer informed other officers to just keep a visual of the defendant walking down 12th Street towards Juniper until the other officers arrived. Once the other officers arrived, they exited their vehicle and the defendant ran down an alley located at 205 12th Street. The officers pursued him down the alley. Another officer was able to drive to the intersection where he observed the defendant running across the street without using the pedestrian crosswalk. They did chase the defendant until they were able to detain him. The defendant then told the officer that he began to run once he observed the officer exiting the patrol vehicle because he was in possession of marijuana less than an ounce. A search incident to arrest did reveal a bag containing marijuana less than an ounce. The state's recommendation on this case is $2,250 surety bond, $1,000 for the obstruction, $1,000 for the possession, and $250 for darting into traffic, the pedestrian darting into traffic, no alcohol, drugs, or weapons. We are recommending the surety bond based on the multiple probation violations in 2012, 2014, 2015, 2017, and his recent convictions for suspended license. And I believe there was a 2017 conviction, which has already been addressed by pretrial. And so that is all for the state.
All right, thank you. Ms. Kim?
Yes, Mr. Tony White is 43 years old, and he was born and raised here in Georgia. He is raising 4 children, 10, 7, 5, 3 years old, and he has all his family members here in Georgia. He works at Holiday Inn as a house maintenance, cleaning the bathroom and the rooms when they get vacated. He does not make a lot of money at this point. However, he does have some college education, majoring in pharmacy technology at Brown Mackie University at Brookhaven, Georgia. He does not have any disability or any kind of addiction, so we would like to request for signature on bond for this. And he believes that the probation has been all over, and I do understand there were 4 probation violations, but that's old issues. We would like to ask for signature on bond.
Thank you. Time defendant will receive $1,000 surety bond, 500 count 1, 250 count 2, 250 count 3 for the total of the 1,000. He is to have no alcohol, drugs, or weapons as a condition. Is there any state or defense?
Nothing from the
Others.
state.
All right, best of luck.
Sorry,
Thank
Judge,
you.
you said $1,000 signature or good bond?
Surety.
Surety, thank
All right, who do we have next?
Position 1, Bogan.
All right, good afternoon, Mr. Bogan. Your case is 22 CR 0059.
Bogan, what have a seat? Not you.
No, I got you.
Come on, Bogan. Put your mask up for me. Have a seat.
Your case is 22 CR 005910F, in which you're charged with fair evasion and criminal trespass. Do you understand your rights?
Yes, ma'am.
All right, Ms. Roberts.
Yes, I am showing a total of 11 cycles, 7 out of Georgia, 2 out of Alabama, 1 out of Florida, and 1 out of South Carolina. Last arrest was April 21st of this year for a failure to appear. He does appear to be on probation out of DeKalb County for theft by shoplifting. The disposition was April 18th of this year, 12 months probation. He also appears to be on probation out of Newton County for disorderly conduct. Disposition was May 10th of this year, 12 months probation. And a second case out of Newton County for DUI and willful obstruction of a law enforcement officer, same disposition date, May 10th, 12 months probation. He does appear to have an open case out of South Carolina. The arrest date was from November of 2021. It doesn't state the charge, but it states that it's a felony. There's no disposition listed.
Okay, that's good. Thank you, Ms. Roberts. Ms. Fulton.
Yes, Your Honor. The defendant trespassed onto MARTA property by entering the Lindbergh station over at 2420 Piedmont Road, Atlanta, Georgia, while having an active suspension. The suspension was effective July 6th of 2022 and lasts till September 5th of 2022. This incident happened on September 1st. He also entered the station without paying fare. As the pretrial has said, he has some convictions from 2022. We're showing a DUI, a disorderly, and a theft by shoplifting, an open case out of South Carolina, which does give us concerns for the flight risk, as well as 3 FTA arrests, which also give us concern for flight risk. We are asking, the bond is currently set at $1,500. We're asking that be reduced to a $1,000 surety bond, $500 on each charge. Stay away from the MARTA at Lindbergh Station at 2420 Piedmont Road, and no alcohol, drugs, and weapons. Thank you.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Nathaniel Bogan is 37 years old. He has been in the Atlanta, Georgia area. He has family here, Your Honor, in Marietta. He does not have any children. He completed college. He has a degree in computer information systems. However, he is unemployed. He was working as a commercial truck driver. However, it's like he had some licensing issues, so therefore he has not been able to work in that field. He tells me that he has a job lined up on Monday in construction. He does not have the means to pay anything toward bond. While I acknowledge my client's history, and also he is presumed innocent at this point, Your Honor, I acknowledge my client's history. However, he informs me that that most recent FTA, and we didn't hear about dates of the others, he was in fact hospitalized, Your Honor. Given the nature of the offenses, I am requesting a signature bond on Mr. Bogan's behalf so that he can be released to get back on his feet to get to work on Monday, Your Honor. Thank you. And we are unopposed to the stay away. Thank you.
All right, at this time, the defendant is going to receive a split bond. It'll be $1,000 split bond. It'll be $500 signature through the jail and $500 surety for the criminal trespass. He is to stay away from the MARTA Lindbergh station and have no alcohol, drugs, or weapons. Is there anything further for the state or the defense?
Nothing from the defense, Your Honor. Thank you.
Nothing from the state, Your Honor. Thank you.
All right, best of luck to you, sir. We're gonna go now to, I think, our last position, position 4.
Yeah,
Mr.
they waived their appearance, so we're completed here in Courtroom 2, Judge.
All right, take care. Have a great long weekend there in Courtroom 2.
Thank you, Sam, thank you.
All right, can I have the history for position 4?
Yes, he has 3 cycles. Last arrest was March 13th of last year. I'm sorry, of this year for battery out of Clayton County. That case appears to be open. And then the first arrest was from 2020 out of Clayton County for battery family violence, and that was a conviction. And nothing further.
Thank you, Ms. Falk.
Yes, Your Honor. This incident happened on August 30th, 2022 at 1125 Dolphin Drive in Atlanta, Georgia. Officers arrived to that location approximately 8:48 p.m. They met with the defendant, who at the time was bleeding from the head, and Deontay Johnson, who had sustained injuries to his left arm. Deontay Johnson, D-I-O-N-T-E, Johnson, common spelling, stated that he had picked the defendant up earlier. They had gone to his apartment. An argument ensued between the two of them, and when the defendant walked outside, Johnson locked the door so the defendant could not get back in. The defendant claimed he wanted his cell phone charger, and he began knocking on the door, and then went and repositioned Johnson's security camera, went to the bedroom window, removed the window screen, causing damage to the screen, which is the basis for the criminal trespass, and then climbed into Mr. Johnson's bedroom. Mr. Johnson went into his bedroom, saw the defendant coming into his house, obviously without his consent, and a physical altercation ensued, whereby Mr. Johnson did sustain injuries to his left arm. The thing that concerns the state here are those 2 previous batteries. We have a family violence battery conviction out of Clayton County in 2020. We do have an open an open battery from March 2022 arrest in Clayton County. I did talk to Clayton County and reach out to them. The case is still open. However, I was not able to ascertain who the victim of that March 2022 battery was. The recommendation on this case is, the bond is actually currently already set at a $7,500 surety bond, $5,000 on the battery, and $2,500 on the criminal trespass. That is correct. And so the state is asking that the bond remain in place. Our concerns are really that the history that the defendant does have shows a consistent history of battery, and now this is his 3rd arrest for battery. He has a previous conviction for family violence battery, so we do have some serious concerns about a risk of reoffense. We are also asking for a stay away from 1125 Dolphin Drive Southwest. That is not the defendant's residence. It is Mr. Johnson's residence. And we are further asking for no further contact with Deontay Johnson, no alcohol, drugs, or weapons. Thank you.
All right, I'm sounding for Mr. Johnson at this time. Mr. Johnson, if you're present and wish to be heard. All right, hearing none. Ms. McLeod?
Yes, Your Honor. My client is 19 years old. He tells me that he was invited by Mr. Johnson to actually move in with him, and he agreed to move in with him. Once he went over to his house and they started having a discussion, he realized that they misunderstood the nature of what this particular move in would entail. So my client decided that he wanted to leave. He had his cell phone charger and a couple of other things in the house, and Mr. Johnson would not allow him to get his things. He asked him and he kept saying, come back at 9 o'clock, come back at, and kept changing the time at which he should come back to get his things. So he said he just wanted to get his stuff, and the window was open, so he went into the window to get his stuff, and he was attacked by the alleged victim, who pulled a gun on him, used the gun to hit him in his face more than once, and just generally attack him. And he was the one, he said, once he said he was going to call the police. Mr. Johnson called the police himself, and my client was arrested. They did not arrest Mr. Johnson because my client feels that Mr. Johnson gave a fabricated version of what had happened and was not totally honest about what had happened between them. I do know that my client has a conviction, Your Honor, but this, based on my understanding from him, this was a misunderstanding that he had with his father some time ago. He does have another open case, but he's not been convicted in that one, so he's presumed innocent. He's not working, Your Honor, and tells me he has a 9th grade education, although he's trying to finish up to get his GED online. I would ask the court to consider his circumstances in setting bond for him, Your Honor. I asked him if he had anyone to help him, and he said no. So I just wanted to bring all of that to the court's attention.
Your
Thank you,
Honor,
Your Honor.
we were able to reach out to the victim. I was remiss in not mentioning this. The victim stated that he wants no contact with the defendant, wants for him to stay away from the residence. The defendant will need a one-time law enforcement escort to retrieve, I'm guessing, his phone charger. And I will say that I am not agreeing with the defense's recitation of facts, but even if all that were true, the fact remains that when someone is breaking into your house without your consent, you can hit them in the head with a gun. You can actually do probably worse to them because you are breaking into their home. So even if we go with everything that Ms. McLeod has said is true, it still does not negate the fact that he was entering the residence without the homeowner's permission.
All right. At this time, the defendant is going to receive a $5,500 surety bond, $5,000 for count 1, $500 for count 2. He is to have no contact with the alleged victim, Mr. Johnson, and he must stay away from the address on Dolphin Drive. He can return one time with a member of law enforcement to collect any items, and he is to have no alcohol, drugs, or weapons. Is there anything further from either the state or the defense?
Nothing from the defense, Your Honor.
Nothing from the state.
All right. I believe that concludes the entire calendar. Ms. Grace, will you review it for me?
Okay. Position number 1 is $1,000 split bond. Position number 2 is a $2,000 pretrial bond. Position number 3 is a $2,000 pretrial bond. Position number 4 is a $5,500 good bond. Position number 5 is a $500 good bond. Position number 6 is a $1,000 good bond. Position number 7 is a $4,000 pretrial bond. Position number 8 is a $750 good bond. Position number 9 is a $3,000 split bond. Position number 10 is a SOB through the jail. Position number 11 is a $1,000 good bond. Any questions or concerns?
Yes, the first case. Oh, no, I got it. Actually, nothing. Thank you.
You're welcome.
Hearing no further comments or questions, will be in recess until tomorrow's SCA calendar, at which time I will be present. Take care, everyone. For those who will not be with us tomorrow, enjoy your long weekend.
Thank you, Your Honor. Have a great weekend.
Judge.
Bye.
Thank you, Your Honor.
And Judge, I also emailed you the 2 waiver forms.
Okay, did you send them as PDFs?
Yes, I did.
Okay, thank you.
All right.